Hi everyone. 2024 had a lot of cases, and one case that came out will change my practice forever. This case called Wiese, Marriage of Wiese, W-I-E-S-E. And in that case, husband and wife 30 years ago, and I'm just going to make up some facts for the purpose of this particular video. For the demonstration purposes, it would be easier to focus on only relevant portion of that case. Husband and wife had a premarital agreement where they both agreed that his income is going to be separate, her income is going to be separate. They lived happily, maybe not so. 30 years later, she decides to divorce him, challenges all kinds of stuff, the prenuptial agreement, whatever she can. The bottom line is, during the marriage, he made more money. And for the purpose of demonstration, let's assume he made $1 million. And she made $100,000. And what she's claiming is, according to the prenup, your money is yours, my money is mine, but because we filed jointly, if I filed separately, I would have paid only 20% tax bracket, but because we filed jointly, you took, husband, 50%. And therefore, for all 30 years, I'm claiming you violated fiduciary duty. She cited a code section that didn't apply, so the court corrected it in appeal. Eventually, the lower court, the superior court, decided husband owes wife $1.3 million for over withholding 50% of her taxes. That decision was reversed, and the Court of Appeal said, no, if she paid her taxes separately, then she would have paid 20% based on her tax bracket. Just because they filed jointly, he should have reimbursed her the difference, the 30% that he overcharged, but there is a statute of limitation. She used the wrong code section. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. There are two code sections about fiduciary duty. So she needed a code section to have standing. And so she used actually two code sections. 1101, which is violation of community property fiduciary duty. That didn't apply here because her income is separate, his income is separate. There is no community property violation. So then the Court of Appeal relied on 721, violation of fiduciary duty, but it said because it's a violation of fiduciary duty on separate property and there is no statute of limitation in that section around 721 Family Code, we're going to use the California Code of Civil Procedure Code Section 343, which has 4 years limitation from the time the claim was made known, meaning whenever for the first time wife's lawyer said, you husband violated my client's separate property fiduciary duty, then going backwards. So let's say the husband, if wife's attorney made it in 2018, then from 2014 until 2018, that's when the claim would be calculated, and only for the difference of 30%. So if husband withdrew 50 instead of what he should have, refunded her 30 because she was obligated to pay her tax anyway, even if she filed jointly or not, she would have paid her taxes on her income. How do I change my practice based on this case law? Well, first of all, because her lawyer made this argument of violation of fiduciary duty before the trial, time passed, and last 4 years could have been 4 years after the date of separation, making this claim obsolete because there would be no claim. So whenever I have a petition or response, now in FL 100, FL 120, depending who I represent, petitioner or respondent, in number where it says separate property, we usually put TBD, and I will say TBD and 721 violation. Why? Because if I wait, then I lose the years of the time that I could claim fiduciary duty violation. Even if there are none, it doesn't hurt to say because I preserved the right for the last 4 years. That's number one. Number two, how often do we have clients who draft prenups, and usually in cases where one party makes more money and the other party makes less money, they agree, my income is separate, your income is separate, we have no community. What will happen, based on this case, it will give both parties ideas to come back and ask for overpaying on taxes. Meaning, even if they can go 4 years, they will try to do it. So prenup can prevent it. If we put in the prenup language saying, if the higher earner overpaid, they don't get reimbursement back. If a lower earner also has been over-withdrawn, husband and wife over-withdraws money from the lower earner and they file jointly, then they waive their claim. Basically, bygones is bygones. If you guys decide to file taxes jointly and it says separate is separate, then you got to negotiate a deal to say, hey, reimburse me my 30% or whatever the difference would be because of the high earner tax bracket, so be it. But I don't want any of these claims and cases of appeal to come up, because now we know how we prevent this from potentially becoming a big dispute, like in this case. So I hope that was helpful, and I'll see you in my next consultation. Bye!